In continuation of our analysis of contractual terms, what I want to do here is start talking about the various types of terms that may exist in a contract. And we're going to begin with arguably the strongest of the contractual terms, which are, of course, conditions. We'll spend a little bit of time about the nature of conditions in this video before we start looking at other parts of a contract, things like warranties, for example. And we will examine the nature of the binding nature of conditions, the authority that they are attaching to, as well as some other subsidiary factors therein. So, the previous lesson, what we did was spend a little bit of time talking about the approaches that are taken when it comes to the incorporation of terms into a contract. And this lesson is going to start to look at those terms themselves. We will start talking about the first type of contractual terms that are incorporated into a contract. These contractual terms, of course, being conditions. So, in terms of types of contractual terms, when we look at the content of a contract specifically, we can broadly categorize the terms that exist into three main distinctions. We have conditions, we have warranties, and we have what are known as innominate terms. For the most part, things are conditions or warranties. Innominate terms are a little bit less utilized, or not often there as much. And generally speaking, of course, because we're not now talking about the creation of contracts, which was topic 1, we're talking about the actual content of a contract itself. We can generally delineate and define them into these three categories. You could theoretically take any contract and you could have 3 different highlighters, and you could highlight which are the conditions, which are the warranties, and which are the innominate terms. And then there are a couple of other little pieces that may exist as well. This lesson is going to focus on the first of these, and then the next lesson will focus on the concept of warranties, and then the lesson after that will focus on the concept of innominate terms. Conditions will specify the most important part of the contract itself. Now, they are essentially what Go-To considered to be the root of the contract. Contracts very often have a number of very key goals that they are trying to achieve, very key conditions that are essentially the most important part of the contractual arrangement. And then from there, you have you may have other conditions, which are also very important, but then you will also have other terms like warranties and innominate terms. Given that conditions are essentially the most important part of a contract, the most important part at least of the terms of a contract, and in addition to the fact that they represent something of the root of the contract itself, the heart, if you will, the purpose of the contract itself, where there is a breach of a condition, this will often give rise to the most important range of remedies which are available to the aggrieved party. So one of the things that's very important when we talk about contractual terms is being able to identify which of the terms are conditions, warranties, or innominate, because that will inform the extent to which we have different remedies available. Conditions will most often always have the strongest remedies available for their breach, because it would represent a breach of the most fundamental part of the contract itself. One such example of this comes from the 1876 case of Poussard and Spiers and Pond. This case exemplifies, in fact, the issue of breach in context of a contractual condition, because what this involved was an actress who had a contract to lead in an operetta. And so this really strikes at the heart of really what a condition is, what a warranty is, and the distinction between the two, and why this distinction is so important for when we actually get to looking at breaches of contracts. Before the first performances could be done by her, she had to cancel on the basis that she had fallen ill. The defendants then sought to replace her with somebody else who was able to do the performances on the nights that she could not. Now, she would then sue the people who were in charge of the operetta, the people who owned the theatre or whatever it was. She would then sue those people for a breach of contract. And it was held that she could not make a valid claim, since her performing in the operetta, her performance was so central to the purpose of the contract itself, it represented a root to the contract, a root of the contract, therefore representing a condition. It was therefore the case that she had breached the contract, in fact, by failing to fulfill her duty to perform on those nights. So, in fact, rather than the operetta failing to uphold their end of the contractual arrangements and breaching their contract, it was in fact the singer. It was in fact the person who had the lead in the operetta who was performing that was doing the performance. They had in fact breached the contract by failing to do the performance on the night that she was ill. We will get to a different case that is similar in a different lesson, in the next lesson, I believe, or the lesson after, which involves a very similar set of circumstances, but whereas in this case, you see that the breach comes as a result of her failing to perform in the operetta, there was the allegation that the breach came in regard to their failure to actually turn up for rehearsals. And so the question there was whether or not rehearsals actually was something that struck to the heart of the contract and therefore represented a condition in the same way that a performance did. And that's something that we'll get to in the next lesson. It's very useful in the law of contracts, in fact, because there are lots of cases where there are a very similar set of circumstances, but where there are slight differences that clearly exemplify the difference between a term and a warranty, or the difference between offer and acceptance, or the difference between the postal rule or consideration, or all these different kinds of things. So these are really useful illustrations of how contracts actually work on a day-to-day basis.